Okay. We have some preliminaries that we need to get through, so at a duly noticed public hearing on this matter held on March 6, 2014, the Commission voted and decided to conduct this contested case hearing as a whole upon allowing intervention and granting standing to Mr. Inaba. Presiding officer means any commissioner or hearing officer duly designated as such, unless otherwise designated. I, as your chairperson, shall be the presiding officer pursuant to Rule 1-3, letter O. Are there any objections to these arrangements from the parties? From any of the commissioners? The presiding officer controls the course of the hearings, administers oaths, rules on questions of evidence, holds appropriate conferences before or during hearings, rules upon all objections or motions which do not involve a final decision of the proceedings, receives offers of proof, fixes the time for the filing of briefs, disposes of any other matter that normally and properly arises in the course of the hearing, and takes all other actions authorized by law that are deemed necessary for the orderly and just conduct of a hearing. Essentially, the presiding officer can take action which does not involve final determination of the proceedings. Example, granting continuances without the need or wait for the commission to have a meeting on vote on the request for continuance. Are there any objections to this arrangement from the parties? From the commissioners? Planning Commission Rule Number 4 governs. Parties may waive or amend procedures by stipulation, agreement. Once the hearing commences, the parties will be asked if they have any arguments to waive or amend the procedures, so please be prepared. Rule number 4-20 requires public testimony prior to the commencement of the hearing, on each day of the hearings. So after these housekeeping matters are concluded, we will begin taking public testimony. Parties have right to present testimony, cross-examine, and present documentary exhibits. Strict rules of evidence don't apply. The Commission shall not be bound by the rules relating to the admission or rejection of evidence, but may exercise its own discretion in such matters with a view to do substantial justice. The presiding officer shall rule on the admissibility of evidence. Such ruling may be reviewed by the Commission in determining the matter of the merits pursuant to Rule 4-17, letter B. Parties have a right to appeal the decision to courts per Rule 4-27 and HRS Statutes 91-14. Any questions from the parties? From the commissioners? Updating of record. The parties have submitted their witnesses and exhibits, lists and exhibits, with applicant providing and RADA to their exhibit list dated May 16, 2014. The applicant and intervener have submitted their statements of the issues. All of these materials have been served on the parties and provided to the Commission. Included in these materials is intervener's May 9th, 2014 request to applicant calling for the production of documents and things, applicant's objection and response to intervener's request for production of documents and things dated May 21st, 2014. By letter dated May 22nd, 2014, applicant serves on parties written testimony from their witnesses, Mr. Schaefer and Mrs. Martin. Letter dated May 28, 2014 from intervener requests assistance from Commission to compel applicant to allow inspection of all items requested by intervener May 9, 2014. Request to applicant calling for the production of documents and things. The procedure. After the conclusion of public testimony, the commission must address and decide on the letter dated May 28, 2014 from intervener requesting assistance from commission to compel applicant to allow inspection of all items requested in intervener's May 9, 2014 request to applicant calling for the production of document and things. Note applicant's objection and response to intervener request date May 21st, 2014. After the decision is rendered to the intervener's request, I will give opportunity for the parties to admit their exhibits to the record. After the admission of exhibits to the record, the applicant will present its case. Once applicant is completed with its presentation, it will be followed in turn by interveners, Darinaba, and concluding with the planning director. Are there any questions to our procedure for today? We have no public testimony, so we'll move forward. Will parties identify themselves for the record?
I'm Corey Schaefer, Principal System Performance Engineer for Verizon Wireless.
Danette Martin, Consultant Verizon Wireless and General Dynamics.
Trisha Nishimoto of Cade Shetty for Cellco Partnership Doing Businesses Verizon Wireless.
Deputy Corporation Counsel Jennifer Ng for the Planning Department and Director Dwayne Kanuga, who is present.
Darrell Linala, representing myself.
Do the parties have any agreements to waive or amend the procedures? Have the parties agreed to the level of formality?
I don't know if we've agreed to anything, but less formal the better for me.
Okay. Transcripts of hearings being made, so only one person will speak at a time. Okay. Could you please all raise your right hand? Do you all swear or affirm to tell the truth on this matter now before the Hawaii County Planning Commission? We'll start with the applicant.
Are we going to address the Mr. Inalva's request for production of documents at this time? Or
Yes.
yeah.
Yes.
Okay. Okay. Well, our position on that is that his request is not permitted by the Commission's rules of practice and procedure. According to Rule 4-13, it allows for a subpoena of records, but not for a broad, extensive document request as Mr. Inalva's. And to the extent that Mr. Inaba relies on Hawaii Rules of Civil Procedure 34, that is a discovery rule applicable to only lawsuits filed within the circuit courts of the state of Hawaii. And we would submit that this pending administrative hearing is not in a circuit court in the state of Hawaii.
Thank you. Anyone else from the applicant? With Mr. Nava, you have a statement.
My only statement is, I requested the documents and I referenced that Rule 34 because I was informed this kind of follows like a regular court hearing. So if that was wrong, I understand that, but I requested the documents so I could better prepare myself. And also, if I was able to review more documentation, I think I would take less time here today. But since I haven't been able to review anything from them, it may take me longer, but if I'm not able to review their documents, that's fine. I'm willing to go ahead. Thank you.
Does the director have a comment?
The department takes no position on the request for production of documents.
Do the commissioners have any questions at this time for the applicant or the intervener? Okay, if there's no further questions, as chair, I will favor with the applicant and deny the request for the production of documents and things.
Okay, thank you.
Okay, the applicant, you may proceed.
Okay, at this time, I'd just like to confirm that Verizon's exhibits A through K have been received and entered into evidence in the record.
Are there any objections? Commissioners? Okay, hearing none, those exhibits will be admitted to the record.
Thank you.
Mr. Nava? Director? You got it?
No objections from the planning director.
You have the exhibit done, you can proceed.
Yes, at this time, by stipulation of the parties, we would ask that the Planning Commission accept the Planning Department's background and recommendations, exhibits 1 and 2.
Excuse me, Mr. Chair. I wasn't familiar with the procedure, but if I can have my exhibits accepted as well. I thought I had to wait till it was my turn.
Okay.
I have exhibits 1 through 42. And am I able to replace 2 of the exhibits? Because in my rush to prepare them all, 2 of them weren't color, and I was intending them to be colored. So would that be okay with the planning department and the applicant? It's exhibits 3 and 16.
Do you have a copy?
Do you have any objection?
I have no objection to replace it, but I do have objections to some of the exhibits submitted by Mr. Inaba. And I'm not sure if the commission wants to go over that now or after you rule on his request.
Okay. I'd like to take the request for the
Okay.
colors replacement first. Do you have any objections to that?
None to Mr. Inaba's exhibits or the proposed replacement exhibits. We would like a ruling as far as the admission of the planning department's exhibits as well.
Okay. Could I finish, take his one first and then I'll come back to this, okay? Commissioners, any objections to those two? Exhibit 3 and 16?
Thank you.
I'll come back to the department's acceptance. I want to finish the interveners. Okay, we have no objections to exhibits 3 and 16, but as for the list of exhibits, are there any objections?
Yes, we have a few objections that we'd like to place on the record. I would like to object to exhibits 4, 5, 6, 7, 15, 16, 20, 21, 22, 23, 27, 29, 37, 38, 39, and 40 on the grounds that they are either confusing or irrelevant to the present application for the use permit. If I could further submit that specifically these exhibits deal mostly with an application for a special use permit in another matter that is not relevant to the present application. If the commission would like me to go into specifics, I can go through it one by one, but I don't know if that's what the commission wants me to do.
We have a testifier that signed up. She got lost. So, in order to follow procedures, I would like to bring her up before we continue.
Okay, sure.
Thank you. Could you have Antoinette Thompson please come up? Could you please raise your right hand? Do you swear or affirm to tell the truth on this matter now before the Hawaii County Planning Commission? Okay, could you please state your name and residence, and you have 3 minutes to testify.
Antoinette or Tony Thompson without the D, and I live at 16-2068 Paradise Court. I'm on the corner of guess I'm speaking in favor of this tower, and I'm sorry I didn't hear what everybody else said, but I'll just say what I want to say. So I'm not influenced by anybody. But I really think it's important we're getting more and more people up there that are coming in, and they're not very rich people, they're just hardworking people, and they're entitled to have the services that a tower would provide as far as access to information. And I think it's very important that people be educated, because I'm an educator, and I'm 91 years old, and I live alone, and I think it's important to have this access to the best kind of communication we can have. Not that they're not good, police are good now, but sometimes, you know, a storm or something could knock something out. And if we have a tower, it'll be another insurance that we have more up-to-date technology at our beck and call. Do I ask for questions, or do I just keep on rambling? I don't know, I think it's a wonderful opportunity for the community, though, to show its willingness to grow in a positive way. And they're widening the road too, and so we're going to need much more ability to use that road, and with wireless facilitating cars and trucks or emergency vehicles coming in the area there, it's so much better. So I'm all for it. And I understand they're going to decorate it like a tree, so it doesn't even look like a tower, so it won't be that like a sore thumb. And I'm looking forward to it. And I don't think it will fall. I mean, it might fall with an earthquake, I don't know. But I think I'm sure that when they construct it, it will be constructed safely, so that there won't be any danger of accident like that. So I think, I don't know if I spoke in 3 minutes or not, but that's about what I have to say, but I think it's a great idea, and I'm so happy that somebody's coming in and having to risk the monetary investment to put it in there for us, the people, because we are a democracy and we need help from everybody. So that's my say. Thank you very much.
Thank you.
I'm glad I found the building.
Any questions, commissioners? Thank you.
A question.
Commissioner.
I'm not familiar with your residence, so how far, are you living close to the tower?
I think I am.
What's the distance roughly?
I think, please tell me the exact spot of the tower.
I'm sorry?
Please tell me the exact location of the tower.
I don't know myself. I'm just
Oh.
wondering, because of your comment, I'm just wondering how far away are you from residing
I'm
from
on
the
the
tower?
corner of, I know, oh. I'm on Paradise Court, right on that corner. Yeah, but right there, on that corner, that's me. That whole section blocking it, so I'm kind of diagonally across from it. And I suppose if it's 100 feet, it could fall over into my yard, but I'm not worried about that.
Okay, thank you.
Anything further? Thank you. Do the commissioners have any questions or comments to these objections? Or would request any of these to be described in detail?
I actually have further objections on other grounds. Should I state and list those first before you ask them to further question me about the current objections?
Yeah. Could you explain as to what other?
Yeah, the other objections are on the grounds that that they lack foundation. To the extent that they were just copied and pasted from the internet.
Could you could you please briefly reference?
Yeah,
Yeah.
those, you want me to start from the beginning or just the ones that I just stated?
No, wait.
Oh, from 4.
From 4? Okay, I'm gonna go through them. Let's see.
From 4 and
Okay. Verizon objects to exhibits number 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 15, 16, 20, 21, 22, 23, 25, 26, 27, 29, 36 through 42. Either because they're confusing and irrelevant to the present application or they lack foundation.
Do the commissioners require further clarification?
No, but I'd certainly like to know from this list of exhibits, which one are you accepting? Seem to be
1 through 3.
1, 2, 3.
I can, yeah, maybe it's easier if I go through it that way. We do not object to exhibits 1 through 3, 14,
Okay.
17, 18, 19, 24, 28, 30, 31, 32, 33, 34, and 35.
The planning director, do you have a comment?
We're taking no position on this except to remind the commission that intervener is representing himself pro bono. So in that case, perhaps there should be some leeway in understanding why he submitted whatever he submitted. That's just a comment I want to make on it.
Mr. Inaba, would you like to comment on those items that are being rejected?
Yeah, I'd like the commission to allow me to present all of those. I wasn't allowed to review any of their documentation at all, zero, other than what was submitted to the planning commission. And a lot of these documents are public record, which I obtained from going to the planning department, looking at the file. And if the public record and things from the internet are not allowed in, where else am I going to get any information to present today? I don't have access to their legal, websites or whatever, case law and stuff. I'm just trying to present my case the best that I can, and I wasn't allowed to do anything from them. So I went to the planning department, I looked through files, which I thought were very pertinent to the case I'm trying to present. They say they're confusing, irrelevant, and lack foundation. I'm not going to read through the whole document. There's specific areas in there that I'm just going to review in front of all of you, which I think are very relevant to my situation. And I don't think saying it lacks foundation, how could they know that if I haven't even presented it yet? So I'm just asking, I would agree that this is better for me to be less formal. That rule of evidence that she referred to that didn't apply doesn't apply. So I would like to present the information that I came up with in the best way I can. Thank you.
Okay, because we are having a lax procedure, I will allow your evidence, and you will have the opportunity to cross-examine.
Thank you.
Thank you.
The department. You have your, present your.
Okay, thank you. And again, the parties are all stipulating to the admission of the planning department's background and recommendations, exhibits 1 and 2. So we'd ask that the planning commission accept those into evidence.
Do you have any objections?
No objection.
Commissioners, any objections? If not, that will be accepted to the record. applicant may, you may start your presentation.
Okay, thank you. As you know, today's hearing concerns the application for a use permit to construct a 105-foot tall steel monopine telecommunication tower in the Tiki Gardens subdivision in the Puna district. The property of the proposed project is identified on the island of Hawaii as tax map key 1-6-102-056. And the land consists of approximately 8,100 square feet. The proposed telecommunication tower is an expressly permitted use under both the Hawaii Revised Statutes and the Hawaii County Zoning Code. The application itself is about providing reliable voice and data service to the maximum number of people in an area where coverage currently is lacking, with the limited number of impacts to the natural environment and the surrounding community. Specifically, Verizon seeks to provide 4G LTE service in the Ainaloa area, which would permit the wireless transmission of voice and data at speeds of up to 10 times faster than normal 3G technologies, which would greatly enhance everyday living and facilitate any types of emergencies that the area may experience. The concerns against the granting of the use permit come from property owners who do not currently reside in the Ainaloa area. And for example, Darren and Sherry Shinsato are two Honolulu residents who own properties across the street from the proposed project site. And their concerns focus around the foundation of the project and any injury that could result in the residential area as a result of the tower falling. Similarly, Mr. Inaba, a Waimea resident, has objected to the proposed tower on the grounds that his property is within the tower's fall radius. Each of these property owners do not currently have residences constructed on their properties. This morning you will hear from Danette Martin and Corey Schaefer. They will both provide testimony on the benefits that the monopine will provide to the residents of Ainaloa, the site selection process, how it complies with the applicable zoning codes, and some feedback that Ms. Martin has heard from some of the residents in the Ainaloa community. The testimony will further demonstrate why this use permit should be granted. Thank you.
Mr. Inaba? Would you like to do your opening statement?
I'm sorry?
Would you like to have an opening statement?
No,
Take your case.
I'll present everything when it's my turn. I don't have to present anything now. Yeah, I'm fine.
We have no opening statement at this time. Thank you.
Okay, you may bring up your.
Okay, I'd like to call Danette Martin at this time. Okay, please state your name.
Danette Martin.
Have you seen the written testimony submitted on your behalf by Verizon?
Yes.
And do you adopt it as your own testimony?
Yes, I do.
Can you tell us your title and your current employment?
I am a outside site acquisition consultant. I work directly for General Dynamics. Can you hear me now? Okay, trying to jump right. I work as a consultant, outside consultant at General Dynamics, who is a turnkey contractor for Verizon Wireless. Turnkey means they give us the project from the beginning when they have the need, and then we take it all the way from leasing, permitting, constructing, and we hand it over to them ready to operate.
Okay, and can you tell us about your background and experience in this industry?
I've worked in as a site acquisition consultant since 1995. I first started with Western Wireless, which was turned into T-Mobile, and I did that for a few years. And then in 2000, I started working exclusively for Verizon Wireless, or General Dynamics, and Verizon Wireless. The only project that I've done besides Verizon Wireless is I did a project for the County of Hawaii Police microwave backhaul. I helped them with their safety.
Can you describe for the commission your role in the project, the proposed project?
In this particular project, I locate the site location. I do all the real estate to acquire the property. I do all the permitting, and that's pretty much it.
Okay. And is there any design criterion that Verizon looks at when they are searching for an optimal site?
So just to start from the beginning, how the process works is I get a project issued to me, and they give me a map. That map gives me circles, they call them search rings, on a map. And recently, they used to be big rings. Now we laughingly call them search dots because they're so small. Technology's changed so much. But they give me a search ring on there that tells me where the optimal location is. And then I go into the community and use my experience and knowledge about where might be appropriate. I always try to start with the community association, as I did with this one. The first day when I hit the ground, I stopped in with Iowa Community Association, spoke to board members, and tried to get some recommendations from them. But the first thing that we really look at is we try to co-locate on existing towers. We try to get away from installing new towers altogether. So we look for tall buildings, we look for existing towers, any kind of structure really that would be suitable. And I did see one existing structure, and that was a T-Mobile flagpole located at the Ainaloa Community Association, and that would not provide the coverage. We already have coverage in that area. So I was told by the radio frequency engineer who designed the project that wouldn't work.
And after, did you further explore any other alternative sites?
Yes, I actually did quite a few. When I first started with the association, one of the board members had said, why don't you do it at my house? So we went and looked at that. That's on Ginger Lane. And then also the association said, hey, we've got big parcels throughout the subdivision. Why don't you do it there? And that sounded like a good idea to me. So we actually went down that path. We called, actually we were going to go forward on the Ainaloa Community Park location. I think that was the first one that we started. And so I got the okay for Verizon Wireless. I submitted my feasibility report, and they said, yes, that looked like it would work. So we started down that. I ordered the title report, and I found that there was a company, a mainland company, that had an exclusive easement for telecommunication purposes for all the common areas of Ainaloa Association. Called them back and the association and asked them about that, and they were not aware that they'd signed away their rights to that. They thought they were only signing for the T-Mobile tower location, but in fact they had signed away everything. So I called them and said, we'd like to lease some area space from you, and then they gave me some super high rent, and I said, we're not talking about New York City. We're talking about an area that, you know, that doesn't have, you know, it's a very rural area and they can't support a high rent there. So we had to walk away from that. And then we went to the, then that's when the board of directors said, well, how about my house? It's right next to the park. Okay, we'll try to do that one. So we were going to go down that path and really started on that. We started to do drawings so that we could bring them to you for your consideration. And then she called and said that they were being transferred and they wouldn't be able to do it. They were going to have to get rid of their house. And then I went back to the community association again, and they said, well, what about Sugarcane Lane? I've got a piece of property, my daughter's got a vacant lot next to it, why don't you put it there? So I said, okay, well, let's go ahead and do that. So I went and did a feasibility report on that. And it was pretty far out of the search area though, so I didn't know if it would work, but I did put the feasibility report in. And then also, I started driving around. I tried calling the big lots. I look at that first, actually. I kind of need to go back a little bit. When I first get these things, I pull up the TMK map, and immediately I start looking at, let's try to find big parcels. And I did try to contact some people to the, my bearings as far as the, right, I did try to, it's kind of west of the current location. There's 4 or 5 kind of larger parcels. I tried to contact them. I could not either contact them or they weren't willing to work with us. And so I was driving down the street and I saw these lots for sale. And I looked them up on the MLS, I remember. And they told me that, you know, they would seem to be very inexpensive. So I talked to Verizon Wireless about whether or not they would be willing to purchase these lots. And so we entered into an option to purchase contingent on zoning.
So you would say that you made genuine efforts to explore alternative options before selecting the proposed site?
Yes, I'll even go further to say that if we cannot get this approved, I don't know where else we can put this.
Okay, now what factors render the subject site optimal?
We look for utilities. The utilities are important. We look for topography, surrounding topography. We look for, try to actually not put it too close to existing structures. However, that's not altogether a criteria of ours.
And I want to address some of the objectors' concerns. For example, Mr. and Mrs. Shinsato are concerned that the tower may fall and cause injury in the residential area. Can you explain to us what you know about tower foundation?
Yeah, I did try to get a structural engineer here to explain this better than me, but I couldn't get anybody that had time for us. So I tried to learn as much as I could about it. I talked to an engineer right here in Hilo, an engineer in Honolulu, and what I can tell you is that when we get to that stage, in order to design the tower foundation, we do a geotechnical sample where they take a drill rig out and they dig 1 or 2 inch hole down into the soil, and then they take that in, they analyze it, and then they try to figure out, what we need to do to design the tower. So this is really not about this tower. We don't have a design for this tower. But I just think that visuals are important. So after we get the soils report, it goes to the tower manufacturer. Sure. What?
Can you speak more into the mic?
Speak more into the mic, okay. So it's got, this design is kind of hard to see from there. And it is 8 feet wide. 34 and a half, this particular one, it could be different because for this side. But just to give you kind of an idea, I'm more of a visual person. So they dig down 34 and a half feet for this one, 8 feet in diameter, and then they install reinforced concrete. This one shows steel rebar every foot. And because the County of Hawaii requires the wind load to be 105 miles an hour, the structural engineer personally goes out or has a responsible employee who goes out and inspects the property, or inspects the foundation to make sure that it's done. I talked to structural engineers and they said, it's really my...
Excuse me, Mr. Chairman, is that, can you have the applicant identify the exhibit that she's using?
Oh. Sure. This exhibit is Paul J. Ford Company Structural Engineers.
It's actually,
It has
she just
nothing
brought
to do, it has nothing to do
today.
with this site, and if you want to just disallow it at all, yeah, that's fine.
Okay.
I'm a visual person.
Okay.
So we were talking though about, I don't know if I'm getting ahead of myself.
No, that's fine. We can keep going about the foundation and the
So the
sustainability
foundation
of Wind Street.
is, there's a new, the county has adopted a new, the 2006 IBC code just a few years ago. Before that, there was 80 miles an hour was the standard before they adopted this new code, although the county's always had 100 miles an hour sustained wind. So it used to be that the zoning code was more restrictive. The code now, since it's been amended, is more restrictive than our zoning code.
In your opinion, would it be more likely for trees and other utility poles to fall in the event of a natural disaster?
You know, I can't say that for sure, but what I can say is that this tower will be designed for 105 miles an hour, probably more because we provide for co-location, and so they beef it up a little bit more. And I can tell you that at 105 miles an hour, it's not going to just be the tower. It is going to be, most probably, I think, would be the antennas or the branches that actually might come off first. I don't see that the tower's really going to ever fall over, but at that point, when you have a hurricane that's going to be that big, and you know, that big of winds, sustained winds like that, you're going to have not just that flying around, but you're probably going to have the neighbor's house and a lot of other things flying around. And so I just think that it's, you know, would be a double standard to say that a cell phone tower that meets 105 mile an hour can't have any damage to it after they comply with code, and then have the house next door's roof fly over. You know, just my personal opinion.
In your 20 years of experience, have you ever been aware of a Verizon monopine tower falling in the state of Hawaii?
No.
Okay. I'd like to direct everyone to exhibits E and F. Verizon's exhibits E and F. One of Mr. Inaba's concerns is that his property is located within the proposed tower's fall radius. Can you explain a little bit more about what Exhibit E represents?
Yes, I prepared this exhibit actually using the county's real property tax GIS system. So you'll see the outline of Mr. Inaba's tower, property, sorry. You'll see that he's got the outline of his property is. And then also I took coordinates. We had a surveyor, we have to provide survey coordinates to the FCC for regulation purposes. So I have that information, and I searched that and used that pinpoint and measured on the Google from the center of the tower to 105 feet, or approximately 100 to 105 feet. It's not really that exact. I'm not all that good at Google, but anyway, it's approximate. And it didn't seem like it even crossed the road. So it's well away from Mr. Inalba's property.
Okay, and then what about Exhibit F? Can you explain what that is?
Yes, we actually tried we actually looked around at the existing residences there and tried to figure the closest area there and to see if it was in a fall radius of an existing house.
And is it within the fall radius of any structured residence?
No.
Excuse me, may I comment at this point on these exhibits?
We'll let the witness complete her testimony, then you can cross it.
Now, the zoning code requires certain minimum setbacks for these types of towers. I believe, according to section 25-4-12, the minimum setback is 1 foot for every 5 foot of antenna or tower.
Right.
Does
That's right.
Does the proposed tower comply with this setback rule?
Yes.
There may also be concerns about the visual impact of the tower. What can you tell us that Verizon will offer to mitigate any of these concerns?
We have the ability to do cell towers, and that could be a pine tree or a palm tree. We use landscaping. We drove by the property this morning and just to take a look at it to see how we might better be able to conceal this so that when you're driving by, truly you can get these to the point where you're driving by and it's really hard to see them. I know because I go out and search for towers all the time, and I've driven by them plenty of times and not seen them. So it was really trying to think of what we could do to mitigate any kind of visual impact for him besides the tower. And I was thinking about, I asked Mr. Inaba if, what kind of maybe landscaping would he like for mitigation. But when I went by today, I saw the overgrowth that's there. And I really think the best way to hide this stuff is just to leave the natural growth there. It's awfully pretty. I don't know if you've seen that, been down that area, but just to leave the natural growth, and I think that it would blend in better.
I'd like to direct the parties in the commission to Verizon's Exhibit D, and also in conjunction with Mr. Inaba's Exhibit number 6. And if I could be clear, it's the second page to Mr. Inaba's Exhibit number 6. Okay, does Verizon's Exhibit D accurately represent the proposed monopine tower?
Yes, actually, it is it's a tower that we installed at Volcano Golf Course.
And looking at Mr. Inaba's Exhibit 6, does that fairly depict what the proposed tower will look like and the surrounding area?
No, he's got a standard conical there, and we're proposing what they call a stealth pole to hide it.
Will the surrounding area also be this barren? on the subject property?
Not from what I saw this morning when we drove by, it was really pretty overgrown.
Can you describe any noise impacts that might result from the construction of the tower once it's actually standing?
They do have air conditioners, but they are really not very loud. I don't think that the neighbors would be affected by it unless it was super quiet. I spent the night in Hilo, Naniloa yesterday, and the coqui frogs are quite loud, so I don't think it's going to be anywhere close to that. But and then we do plan on having an emergency generator, and we do can put a sound cowling on there, and with a 6 dBi, I guess is what they say, 60. I'm sorry, and that is that's pretty quiet. It's about the same noise decibel as an air conditioning unit, which is allowed in this subdivision, you know.
So I'd like to go over the compliance with any of the zoning codes. Can you explain the permitting process and how this tower might comply, or how we can ensure that it will comply with these codes and applicable rules?
Well, let me look at my notes, hold on, I can't really remember what this question was about. Okay, so what I need to do for my job to comply with permitting is we first get that survey that I talked to you about. We order a geotechnical soil sample. We have a professional structural engineer licensed in the state of Hawaii as required by this county to certify that it is 100 miles an hour sustained winds. We file an application, whether it be plan approval or use permit, whatever is required by this by the zoning code. And then we apply for a building permit, and in that case, we're under the 2006 IBC code, which requires 105 miles an hour. And then during that process, during the inspection process, we do the structural engineer comes out and verifies that the foundation is constructed properly.
Is there anything submitted to the Hawaii County Building Department for review before the construction begins?
Oh yes, the building permit drawings, the construction drawings, which include structural drawings, electrical drawings, primarily.
Earlier today you testified that you spoke with some board members of the Ainaloa Community Association. What did they tell you about their current voice and data service, phone service, internet services, and the like?
When I first came to meet with Rhonda and Debbie with the Ainaloa Community Association, they said, "You don't understand how happy we are to have you here. We really, really need this service." This was back in 2011 when I first spoke to them, and they said, "You don't understand. We just got dedicated lines here 5 years ago. Before that, we all were on party lines." So we are really behind the times with our choices. We didn't have any other choices. And we're happy to be able to have that. You know, they also have restricted. Not everyone has the availability to internet in this area of our county.
And in your exploration of optimal building or subject sites for the construction of the tower, did you receive any feedback from any other Ainaloa resident expressing support for the tower?
Yes, I did actually. Tony just called me just a few days ago, and I thank her for showing up. She's sounds like a pretty smart lady, and commend her for making the effort to come out today. But not just that, I also was in the area posting my sign as required by the county on the property, and as I was leaving, there was a lady that was hitchhiking to go to the bank in Pahoa. So I picked her up, and I told her what I was doing there, and she said she was so happy. She said, I don't have the ability to have LAN internet service, and I work from my home, and I'm a graphic designer, and this will mean everything to me, and I'm so happy. So I have spoken to other people too. I haven't had one person that lives there object to this tower.
And of those, you've sent the required notice under the zoning code to all the property owners.
Yes, there was quite a lot because they are such small lots in this area. So I sent out 78, which is 500 feet from the property line as required.
And did you receive any letters or phone calls from any of these residences or residents in the area objecting to the construction of the?
I did not.
Can you describe for us the benefits that will result from the monopine?
Well, the obvious one is that people will have service, and our state has identified the availability to redundant communications is important for safety, but also they've also in the process of establishing a task force to see how we could actually get faster, get the wireless broadband, because they understand how important it is for our economy. It really is, and will bring a better economy to this community.
How about emergency services? Will that be improved with?
Well, absolutely. Verizon Wireless is required to provide E911 service, and so in the event of a problem, I heard in another location in Pahoa, there was someone that drowned, and gosh, if we had the wireless service available, we don't think that person would have died. So, we hear those stories all the time.
Is there anything else you'd like to add?
I did want to point out that in our exhibit that I did reach out to the Ainaloa Community Association after this, just prior to this hearing, and I talked with Debbie Box there. She works there, and I don't know if she's a board member. I did put in my affidavit that I thought she was, but later on I think maybe she just works there. But I talked to her, and I said, I know that we talked before, and that you had said that the association was supportive of this, but would you be willing to write me a letter? So her question to me was, who is objecting to it? And I said, well, it's Daryl Inaba. He's on Silver Sword, and just to let you know, Silver Sword is not in the Ainaloa Community Association. It's in Tiki Gardens, and they have no community association. So I explained to her, I said, well, there's the fellow that lives across the street, or doesn't live across the street, but he has a vacant lot. And I told him what his concerns are and things. And she said, well, he just doesn't get it. He doesn't understand. He doesn't live here. And she said, if he lived here, he would know how critical that this service is to us. I will absolutely get that letter for you. And she did.
Thank you. Are there any questions for the commissioners?
Yeah, you just answered one. I was wondering if Tiki Gardens was a separate entity from Ainaloa. It is.
It is.
And yet you keep referencing, the Ainaloa Community Association, but the project is in Tiki Gardens.
It's kind of on the cusp. Technically, it's in Tiki Gardens. Tiki Gardens is, the coverage is mostly going to be affected for Ainaloa Gardens. And I can let Mr. Schaefer explain to you why this site is going to be the best coverage area for.
Well, I have one more question. I mean, this one's been answered. The other question, is there a recommended distance or buffer zone from the tower for residences for microwave or radio frequency radiation?
I kind of answered this before in the last meeting, but the FCC has strict regulations for safety. And I don't think I brought it with me this time, but there's an FCC brochure that's put out. And I was trying to hand that out at the last hearing, but I don't think I brought them with me. I can forward it over just in case anybody's wanting to know what it is. But basically it says that you have to be 2 feet in front of the antenna for a prolonged period of time for it to have an adverse effect.
That's the FCC's?
FCC's brochure.
Mr. Napa, would you like to cross-examine this witness?
Yes, thank you. A couple comments. They mentioned that they comply with the setback rule. This tower is 105 feet, and the rule is 1 foot for every 5 foot of tower. So they need a 21-foot setback on their plan. If you go to their use permit application, the second to the last page, their overall site plan, it shows 20 feet. And I checked with planning. I walked into planning one day and I said, hey, if somebody comes in with some plans and they don't show the correct setback, could that plan still go through and get approved? And they said, no, we would kick it back to them. Unless it shows the correct, even if they have room, whether I'm not sure if it does, but if it's supposed to be a 21-foot setback, it should show 21 feet on the plans, and theirs does not. It shows 20 feet. So I wanted to put that on the record. I believe that's incorrect. On the exhibits E and F that were brought up earlier.
Excuse me, Mr. Nava. We would like to stick to cross-examination for this witness.
Yeah, they were talking about exhibits E and F.
Yeah.
Oh, so I'm supposed to ask them a question? Oh, so is your setback correct? Does it show 21 feet?
Oh, does it show? No, it doesn't. It says 20 feet. You're correct.
Okay, thank you. So, I think something else. On exhibit E, I believe this was prepared by Ms. Martin, and she discussed it earlier. All the lot lines in Tiki Gardens continue on. It's like a big grid. So they're not offset. So I guess in this case, the north boundary line, the long length of my property, would be a continuation onto their property. With that being the case, if they're setting their tower back 20 feet from the north boundary line, it should be actually lower on the page. It shouldn't be above the north boundary line on my side. I don't know if everybody can follow that. This is exhibit E that Ms. Martin prepared. Oh, sorry. So, do you understand what I'm saying? Where the north boundary line of your parcel where you're siting the tower, it should be a continuation of the north boundary line of the parcel you're identifying as mine. And if that's the case, and you're setting the tower back 20 feet from the side setback, it should be further lower on this picture. Do you have any questions, Ms. Martin?
I can't comment on that. I put in the coordinates into Google Earth and I use the county's website. If it's off a little bit, it might be.
Okay, and then if this picture is off, if you went to exhibit F.
Yeah, it's still across from your property, right?
No, I'm trying to get to exhibit F. So if that tower is a little high on the picture, if you went to exhibit F and it's a little lower than it should be, that tower may fall on that structure, and that's all I said. The tower may, or it appears it may fall on the structure.
Even if it was off, I actually, interestingly enough, I met the guy that did the website for the real property tax last night. And I talked to him about this issue, and I said, it looks like when you go to these sites that it's off a little bit. And he did say that it was off by like 3 degrees or something, and that they were working to fix that. But he said it's obvious what the adjustment is, because you can see that the lot doesn't line up with the street like it should. So even if it was to be adjusted that way, and even if this was to say, the tower was to stay where it is, and Mr. Inaba's property would border the street, it still wouldn't cross over.
No, I never said it would cross into my property. I'm talking about Exhibit F, where you're showing that it doesn't reach a structure on that parcel 49.
It's still
I'm saying
survey
if the tower
coordinates.
were supposed to be further down or lower on this picture, it would be closer to the structure. That's all I'm saying. It appears it may hit the structure.
So these are survey coordinates. These coordinates are correct. The tower is where I'm showing it on here, unless Google Earth is wrong, and that's
I would
rare.
agree with you that the person told you that it may be off. I would agree, and I would just say that both of these pictures are
not
unreliable.
these coordinates. I'm talking about the map itself. And you can tell by you looking at, yeah, the TMK line's off, not the map itself.
Well, you can't, nobody can be sure of that. I'm just saying these two maps are unreliable, and we shouldn't rely on them. You actually said that the person you talked to said they were probably, it's not entirely survey accurate. There could be discrepancies, and I'm just saying they're unreliable.
Actually, survey coordinates, as a matter of fact, I have them with me. Even survey coordinates have, even they have a margin, so an acceptable margin. So, for instance, the accuracy certification is 15 feet horizontally and 3 feet vertically. That's its survey coordinates. This is, even surveyors have to have some kind of an accuracy in there. I mean, it's still, regardless if it's 3 feet or whatever, it's still not going to be on his property or hit this house. I mean, it would have to go 10, 15, it'd have to go, I don't know, to hit this house or to hit this house, probably have to go double the size of the tower, and it's not off like that. If it's off by a small degree. I don't think the coordinates are off, though. The coordinates were surveyed.
Let's move on. You mentioned Exhibit 6. It doesn't reflect what the tower would look like. It's a monopole versus a stealth pole.
Right.
And the only reason I included that type of pole on my exhibit was Verizon never included a nice picture of, I guess it's called a monopine, until they submitted their exhibits. In their application and their statement of issues, they never included an accurate picture of a monopine. So I had nothing else to use other than what I could pull off the internet, and that's what I used.
For the cross-examination, could we keep it to questions to the witness instead of statements? And although we are informal, we don't want our cross-examination to be argumentative. Could we just stick to questions? Thank you.
Okay, understood. Thank you. One last question, if I may. You stated that you answered Ms. Nishimoto saying that you notified all the parties within the 500-foot radius, and you stated that you never received any feedback. Isn't it true that I called you after I received the first notice on this matter?
The question that I was asked was, have any residents contacted residents? in the 500-foot radius. Has any residents objected to it? And my answer was no.
Okay, I misunderstood the question. Thank you. Thank you.
Director, have any cross-examination?
No questions, thank you.
Okay, I was informed one of our commissioners has a appointment at 2 o'clock, and we will not have a quorum when she leaves, so if we don't get completed, then we will have a continuance.
Okay, I'd next like to call Corey Schaefer. Could you please state your name?
Corey Schaefer?
And have you seen the written testimony submitted on your behalf by Verizon?
Yes, I have.
Do you adopt it as your own testimony?
I do.
Okay, what is your title and current employment?
I'm a principal system performance engineer with Verizon Wireless. I've held my current job since 2006.
And what is your background and experience in this industry?
I've been in the wireless industry since 2004 and working in this specific job since 2006 and working in this specific job in the state of Hawaii since 2007.
What was your role in the proposed project?
So basically, I'm the engineer, the field engineer, so I'm responsible for understanding the existing coverage. So I was instrumental in developing the search ring that was sent to DNET, and it's based on where is our weakest coverage today and where can we put a tower that will cover the largest area with the smallest impact on the community. So those are the design criteria that we used to pick this location.
And how are these coverage holes identified?
Through 3 methods primarily, drive testing the network, where we just drive around and collect data and check the signal levels, customer complaints, which we get a large number of in Ainaloa, and propagation studies, which are computer simulations of all our towers. So if you've seen the coverage maps that they show on the commercials, those are propagation studies. And there's one as an exhibit as well.
Okay, is there a reason why these monopine 4G LTE telecommunication towers need to be closer to certain residents as opposed to in the middle of nowhere where it won't be a bother to anyone?
Sure. Yeah, the real reason that we need to put towers close to the users is so that the signal is good. So the higher the signal, the more efficient the signal, and the fewer towers we need to build. So if we were to build towers on the outside of communities and tried to shoot in, it would create a number of technical problems, but it would also require 3 to 5 times as many towers, which is not something that we'd like to do from a cost perspective, or litter the landscape with more structures than is necessary.
And I know Danette has gone over some of the design criteria. Is there anything else you'd like to add with regard to radio frequency and coverage?
No, other than the search ring that we developed for this area was based on the existing drive data and the computer simulations showing that this would be the best location. And it's a range on a map that gets sent to Danette, and she goes out and looks for any properties in the area.
Okay, and of the alternative sites that you've explored or Danette has explored, why were they unsuitable in terms of coverage?
So I think a total of 6 different things have come across my desk, and I had approved several of them, as Danette mentioned. The one fell through. She mentioned the reason that several of them fell through. There were 3 that came across my desk which were unsuitable for technical reasons. So the first one would be the Ainaloa Community Association on Ainaloa Boulevard. And that is on like the eastern part of the neighborhood where our coverage is actually still pretty good. So if we were to build a cell site there, we'd still need to build a second cell site in the western portion of the neighborhood. So that's why we rejected that location. There were 2 more locations brought to our attention on, Sugarcane Lane, and that's a bit too far west in the neighborhood and would also require a second tower. So this location on Silver Sword Drive is in the middle of the neighborhood. So it's ideal because it's kind of situated on a ridge line. So basically we can build 1 tower as opposed to having to build 2 or 3.
Okay, and can you, if everyone can take a look at Exhibits G and H, Verizon's Exhibits G and H. Can you explain to everyone what these represent?
Yeah, so Exhibit G is basically the coverage existing today. This is one of these propagation studies that I mentioned, and this is a computer simulation. So all these little dots you see with different pie shapes coming out of them, those are our existing towers. So you can see the signal. Typically when it gets down into the green and blue, the signal is very poor to non-usable. So you can see that the center to western part of the neighborhood is the part that needs the most improvement. And you can see the proposed Ainaloa Tower right in the middle of that neighborhood to try to capture all that area with a single tower. If we were to go too far northeast or too far southwest, we can't basically pick up the whole neighborhood, and it would require us to build more than one tower. So if you look at Exhibit H, this is basically the proposed coverage with the Ainaloa cell site. And you can see that it eliminates a lot of the blue coverage and almost all the green coverage as well, which are the poor coverage areas.
Okay, and just in very concisely, can you just explain why the subject site was the most optimal?
Yeah, basically, because there, as you drive up Ainaloa Boulevard, you'll notice that it peaks right before this area. So basically, because of the topology and the ridge lines in the area, if, as I've mentioned several times, if we went too far east, we'd have to build a tower for the east part of the neighborhood and a tower for the west. We'd much prefer to build one tower in the middle. So there's a pretty limited, probably 4 or 5 streets worth that ridgeline takes up, where we'd accept any property in that area. And we did approve two properties in that area that fell through for other reasons. So.
Okay, and lastly, I just want to take a look at Exhibit C, Verizon's Exhibit C. C, as in cat. Is that a current and accurate depiction of the surrounding area, the immediate surrounding area of the proposed property?
Yeah, it looks correct. We saw it today, and it looks just like this, I'd say.
And a lot of times people don't want telephone poles, utility lines, electrical lines in their line of sight, but we have them anyway because of the trade-off and benefits they provide. The area is already, as the pictures depict, filled with these, correct?
Correct.
Okay, is there anything else you'd like to add?
Nothing else.
Do the commissioners have any questions for Corey?
I have one. I'm pretty satisfied with the structural integrity of these and the visual impacts, have been mitigated. And forgive me for, going back to the radiation concerns. The smaller rings that you're talking about, does that mean that the technology has improved to where there's not as much radiation danger as there was in the past?
Absolutely. So over the years, wireless technologies have decreased in power. So if you go back to the old analog days, people's phones that they carried around bag phones, car phones, those were 3 to 6 watts. The highest your phone can transmit today, according to the FCC, is 250 milliwatts. And one thing to keep in mind, Danette talked about how you have to be very close to the antenna for it to cause any radiation. Over 99% of the areas that you'll be, your phone is going to expose you to more energy than the tower. And that's because the energy from a radio signal decays as 1 over the distance to the source squared. So that's like a really quickly dropping curve. So if you stand, for example, if you were to stand at the base of this 100-foot tower, as close as you could get to it, your phone would be transmitting about 1,000 times hotter than the tower at the location of your head. So I encourage you to use your headsets. But the FCC has determined that, so we're still at a much safer place than we've ever been, 1/4 of a watt. And some of the new FCC regulations, they're using proximity sensors. So if you're closer to it, it even clamps your power down to what we call 10 dBm, which is significantly lower than 250 milliwatts. That's closer to 10 milliwatts. So the power, as the cell density increases, our exposure to radiation actually decreases because the cell phone is closer to the tower and the cell phone can talk much quieter. So if you live out in a rural area, you're actually exposed to the most radiation if you own a cell phone because your cell phone has to scream to be heard by that tower. So the person who's exposed to the least radiation is the person closest to the tower because their phone can talk the most quietly. Because the downlink coming from the tower to the phone is always much, much quieter than the phone itself because of your proximity. So the point where the phone becomes equivalent to the tower is roughly 5 feet away. So you have to be quite close. And we do these EME studies, and the FCC does not even require them for towers because they're so tall, there's no way anyone could get in front of there. But we do those on rooftops, and that's a very serious thing. We measure everything. So it's a much bigger concern on like apartment buildings where people live closer to the antennas. But for towers, never comes up.
Okay.
Any further questions from the commissioners? Mr. Inaba, would you have any cross-examination for Mr. Schaefer?
Yes, thank you. I just had a couple of questions. Would a greater area of the Ainaloa subdivision be covered if the tower was located on the Ainaloa side of the boulevard? I'm looking at Exhibit H, and toward the bottom of the subdivision, there's a lot of yellow, green, blue to the bottom of the subdivision. And my question is, if the tower were actually moved onto the Ainaloa side of Ainaloa Boulevard, would the coverage improve?
No, not. Basically the terrain is flat across the road there, so there wouldn't be any increased coverage from moving it.
Would in these cell towers is a higher tower? Would that improve the coverage?
Typically, that's true. Yes.
That is true.
Yes.
For the other towers that are shown on this Exhibit H, the coverage areas seem broader. What is the reason for that?
Mostly terrain. So if you look at Hawaiian Paradise Park, for example, that's the Verizon tower right at the church there, right on the main highway. Hawaiian Paradise Park is like a gently sloping, straight downhill, so it propagates pretty well downhill. Ainaloa, as I mentioned, has this ridge line where it curves. So these computer simulations are based almost exclusively off terrain. They're quite accurate. They're not very accurate in places like Honolulu where you have a bunch of man-made structures, but places where the terrain is the main factor for degrading the signal, the computer modeling is quite accurate. And we compare it to our drive testing, so we verify that.
How high are the towers, like the one in Pahoa and the one in Curtistown?
I think, you're really testing my memory. I think Pahoa is 85 feet. I think Puna is 100 feet. Curtistown is maybe 100 feet. We're at 80. Yeah, we're at 80 feet on Curtistown. Yeah, that's right. We're co-located there.
Okay, but I believe the Puna one is 120 feet.
120. That's right.
Okay, just to clarify.
Yeah, thank you. You know my network better than I do.
So if the tower, increased tower height improves coverage, if you located the tower above Ainaloa Boulevard, it would improve the coverage if the tower was higher.
We could look at that. We'd have to do a study. The terrain is very specific. So if you move the tower, you'd have to rerun this propagation study. So I could give you a guess based on my experience. If it was the same elevation and we raised the tower, the coverage should get better in general, but the devil's in the details of the actual terrain relative to that location. Because basically what the tool does is it goes out in an arc to every one of these dots and looks at how much terrain is in the way, and that's how the signal gets degraded by the computer model.
Okay, thank you.
Sure.
Do you have any cross-examination?
No, thank you.
Ms. Nishimori, do you have any further witnesses?
I do not.
Does that conclude your presentation?
Yes, although I do want to just preserve for the record something that I forgot to go over before we started. I just wanted to preserve our objection to Mr. Inaba's standing in case any appeal is later taken.
So noted.
Okay, thanks.
Mr. Inaba? Would you present your case?
Thank you, Mr. Chairman. Thank you for hearing this contested case for Self-Care Partnership's proposed tower. My name is Darrell Inaba. I represent myself, my wife, and my son. Exhibit 1 is Hawaii County Ordinance number 1017, or Bill 186. My understanding is in 2007, the state legislature passed Act 171, allowing construction and operation of wireless communication antennas as permitted uses in the state land use agricultural district without a special permit. Surrounding owners were no longer able to express their concerns regarding antennas and towers within the immediate neighborhood. I'm aware of Mr. Alfred Souza, who owned property in Ainaloa, and he was unfortunately caught off guard, and a tower was approved without him being able to voice his concerns at a commission meeting like this here today. The purpose of 1017 was to require wireless telecommunication antennas and towers to obtain approval for a use permit from this very planning commission. My understanding is ordinance 1017 was planning director approved, which I'm hoping was to protect Hawaii County residents and prevent people from being in a situation like Mr. Souza was. This use permit process is my only protection that I feel I have. Hawaii County Code section 25-260-267, which is exhibit 2, that's basically the section of the code pertaining to use permits. Use permits are permits for certain permitted uses in zoning districts which require special attention to ensure that the uses will neither unduly burden public agencies to provide public services nor cause substantial adverse impacts upon the surrounding community. I'm here to protect my family's interests in 4 properties located across the street from the proposed Verizon tower. My concerns consist of 3 areas. One is according to section 25-265-2, one of the criteria for granting this permit is, and I quote, the granting of the proposed use shall not be materially detrimental to the public welfare nor cause substantial adverse impact to the community's character, to surrounding properties. This application does not satisfy that criteria. And 2, I feel that there are discrepancies in Selco Partnership's use permit application dated 12/11/13, and there are discrepancies in Selco Partnership's statement of issues dated 5/8/14. First of all, I'd like to state for the record that I'm not opposed to towers in general, just the specifics of this case. My exhibit 3 is a tax map for 16102. The red parcel is the subject parcel Verizon is proposing the tower. The yellow ones are additional properties Verizon is purchasing. I guess they have an option to purchase those additional parcels. And the 4 blue ones are families owned by my family, parcels owned by my family. The reasons I feel Selco Partnership, the use permit application number 14-046 does not satisfy the county code section 25-265 are as follows. 1, I feel there will be a significant visual impact to our properties if a 105-foot tower and related facilities are constructed across the street. This is not regarding an ocean view or a monohull view or a Mauna Kea view. I'm just saying that the tower, a 105-foot tower located right across the street, is going to loom over our property. That'll be the only thing we'll see from our front yard and driveway, if I build a house there. The tower and related equipment will transform our view into an industrial setting, and by that I mean a 105-foot tower, windowless buildings, air conditioning units outside, backup generators, cables, etc. Exhibit 4 is findings. The document is titled Findings of Fact, Conclusions of Law, and Decision and Order. And this is for a previous Verizon telecommunications tower application back from 2005. Our situation is very similar to Verizon's previously proposed tower, and this was in the Orchid Land subdivision. On page 14, if you don't mind turning to page 14. Under impacts on surrounding properties, item 2. Visually, the proposed tower will also be 200 feet away from Pa's home, across the street from which most of the tower will be visible. The tower will also be visible from the Alathen home, partially screened by trees, but only 63 feet away. Interveners specifically objected to the visual impact of the proposed tower. It is well established that even under substantial evidence review, such as under the Federal Telecommunications Act of 1996, land use decisions based on aesthetic concerns can be valid, and that aesthetic harmony is a prominent goal of land use codes. The Commission is entitled to make an aesthetic judgment as long as it is grounded in the specifics of the case, not just an objection to towers in general. And I feel that applies to us here today. Exhibit 5 is an excerpt from a Planning Commission hearing transcript dated, I think it's February 3rd, 2005, but I believe the document should have been dated 2006. On the UN at the bottom of the page, I just want to read a part of it again. The hearings officer seems to think that the fact that somebody doesn't like the way something looks built next to them is to be completely disregarded in the special permit process. That's totally 100% wrong. He says that it doesn't affect the surrounding property, it only affects the feelings of people who live on the surrounding property. Almost everything we say, we have to consider the commonly held opinions of people as to what they like to have in their neighboring property. You know, there's a general feeling, I don't think it's an oddball feeling, shared by only a very few people, that you would rather not look at, say, a 100-foot tower, 100-foot high cell tower right out your backyard. I mean, that doesn't mean that you wouldn't approve it. It doesn't mean that it couldn't have a special permit, but it is. That opinion is entitled to protection in the process of a special permit. And that's quoted from Mr. Yuen, who was the planning director prior to Mr. Puna. I understand planning directors differ, but he did feel strongly about aesthetics being a pretty important concern. I realize that the code has now changed, and this is a use permit application, not a special permit. I still feel we should be entitled to protection, as Mr. Yuen felt 100% sure of. Exhibit 6 is the exhibit, what I thought the exhibit, the monopine would look at in front of the property. I understand it's not a monopine as Ms. Nishimoto said, but that's the only tower I could cut and paste and put onto this picture. And the reason I put it in front of that back house there is because there would be no reference as far as how high the tower was if I just put it in an open field. So that's why I put it so you could see it next to that existing structure there. So in the current location, it's actually further toward this house than it should be. It's not located on the current property, but I just needed a place of reference. Exhibit 7 are photographs of the neighboring property and where the site was to be located for Verizon's previous tower in Orchid Land. And you can see there, there was a lot of nice trees surrounding the site and the neighboring properties. And Verizon proposes to mitigate the visual effect of the tower by planting trees, but there previously existed large, beautiful trees at Orchid Land, and the Commission still found that there was aesthetic impact there. Exhibit 8 is something I just pulled off of the internet. It's an article titled Federal District Court in New York finds aesthetics sufficient to deny the cell tower application. That was dated 10/26/12. On page 3, I believe that's the middle paragraph. It says, in particular, the court found the aesthetic concerns significant. And I feel that applies to me with this proposed tower. On page 3, the fourth paragraph, it starts with the second sentence. The court addressed T-Mobile's three-part claim that aesthetic concerns could not support the denial. Addressing the first claim, the court found the board was permitted by the town code to address aesthetic concerns even though the tower was permitted in the residential zone district by way of a special permit. Next, the court found aesthetic concerns were supported by objective evidence far from being speculative, given pictures taken from the surrounding area during the crane test, the fact that the tower is twice as tall as any tree in the surrounding area, and testimony of local residents stating they could see the tower from their homes. And thirdly, which I find is important, the court found that although there did not seem to be another feasible nearby location, it was not improper for the board to weigh that factor less than the planning department staff or T-Mobile had, as the code did not state how to weigh the factors. Second point is there will be an adverse impact on my family's property values, and this is not, I can't tell you what a specific dollar value would be or any type of percentage, but a tower located directly across the street with an unobstructed view of it will make other properties more desirable. There are hundreds of others to choose from in Tiki Gardens and Ainulua community. My wife has a friend who just moved from Thailand, and they had a cell tower located next to their house, and the mom and the son got sick from the tower. And at our first meeting on March 6, 2013, a lady came up to me and dropped me off a card, and she told me to give her a call. She had information about cell towers. When I called her, she told me that she lived next to the Lualei towers in Oahu, and over there many people got sick from the towers. And other people know similar accounts related to cell towers. Just to be safe, people would simply buy elsewhere. And I'm not bringing those up. I want to clarify that I'm not bringing it up so you can decide yes or no on this tower due to health reasons. I'm just bringing it up because other people are aware of stories like that. And just by having a cell tower next to a property, a lot of people tend to buy elsewhere. As simple as that. On Exhibit 4, which is, again, the findings of fact, conclusions of law, and decision and order. On page 14, again, item 3, impacts on surrounding properties again. Sorry, you have to go back and forth. It is also reasonable to conclude that the property value of the PA residents would be adversely affected by the erection of a 104-foot tower across the street and largely visible from the residence. The commission so finds. I just want to clarify, Mr. Paul was 200 feet away from that proposed tower. Exhibit 9 is an article I found by another Verizon tower they're proposing in Edison, New Jersey. And I feel like it's very similar to mine. The subdivision is more established, but the lot sizes are very similar, with modest homes on them. And one of the property owners, down in the bottom paragraph, is quoted saying, he's opposing a cell tower at Edison Zoning Board hearing on January 28, 2014. Said the cell tower is too close to residential properties, and further stated that cell towers next to residential housing always negatively impacts home values. He said that most people faced with the choice between buying a home next to a cell tower versus a home not next to a cell tower would usually opt for the home not located next to the cell tower. This, he argued, causes reduced demand for properties near cellular towers, and reduced demand always translates into lower property values. My next exhibit is a map of that proposed tower, and again, it's not even in the subdivision. This is Exhibit 10. It's a Google map. The tower wasn't even in the subdivision itself. It was in a buffer area between the subdivision and a shopping center. And it's very similar to our situation, I feel. Third reason, there are very real hazards of a potential tower failure. And there's no protection from a possible tower fall mentioned in the application. On the previous Orchidland subdivision, sorry, go back to Exhibit 4 again. Page 14. It also mentioned there is no specific protection from a possible tower fall proposed in the application. And similarly here, none was proposed again. Other structures could eventually be built within the fall radius or fall zone. Verizon may argue that towers are safe, but recent evidence is to the contrary. And Exhibit 11 is an article about fatal tower collapse. Just when I started researching for this case here, this is in February. 2 towers collapsed while one was being worked on to permit additional tenant equipment to be added to one of the towers. You know, they may be designed to withstand strong winds, 100 miles per hour like they say, but there's other reasons that towers may fall. And this one, all they were doing was adding other tenant equipment, just like they're proposing to do for this tower, but it fell, and people died.
Mr. Nava, excuse me, could we take a 5-minute recess, please?
Yeah, I need some water.
Okay, thank you.
I'm on Exhibit 12 now, and that's another article. This one had a telecommunications towers for the Indoor Line, 2 workers dead in Kansas. This is just dated March 27, 2014. I wanted to bring this article up because on the second page, the collapse of these in the middle, the collapse of these 2 towers resulted in the death of 2 workers and a firefighter responding to the scene, and sent 2 other employees to the hospital with serious injuries. The next paragraph, Dr. David Michaels, his title says, Assistant Secretary of Labor for Occupational Safety and Health. In the last sentence, he's quoted, in the past few months, our workers have been injured and killed by falling objects, equipment failure, and the structural collapse of towers at the road. While these incidents are not as frequent as falls, they are very real hazards to protect against. Exhibit 13 is just a list of catastrophic tower failures worldwide. You know, there's various reasons: storm, maintenance, hit by something. But to say there's no real danger of a tower fall, I don't believe that's accurate. The tower falls all over the world. So I want to reference Exhibit 4 once again. That was the findings of fact, conclusions of law, decision and order. This is item 4. Sorry, I'm trying to do it. Page 14, item 4. The street would be well within the fall radius of the tower, posing potential risk of casualty to those walking or driving upon the road, as well as damage or blockage to the road. And the situation is identical where the tower, the currently proposed tower, could fall into the roadway. For the reason, Verizon does not have to locate the tower at the full site. Verizon has not explored and exhausted all potential alternative sites. Exhibit 14 is a letter to General Dynamics, which I sent on 1/31/14. I thought it was a courteous letter to Ms. Martin. It was very early in the process, and I was just asking for considered, and my request was just ignored. Although Ms. Martin apologized during the initial 3/6/14 meeting, still no information was provided to me. She mentioned confidentiality as her reason, but the previous Verizon agent was more than willing to provide background information to the homeowners of Verizon's Orchid Land subdivision. In turn, the Orchid Land Community Association took it upon themselves to investigate three sites further, and they actually found 3 owners willing to work with Verizon once they took the effort upon themselves to contact them. Exhibit 15 is actually Orchid Land's letter dated 12/5/5, and in that, page 3 and 4, I won't go into detail, but it explains the efforts that Orchid Land took upon themselves. Without much effort, they verified 3 landowners were willing to work with Verizon. Copies of the actual communication are found at the end of Exhibit 15. Without a response or similar open communication with Ms. Martin, I wouldn't know who to follow up with, even if I tried to make an effort on my own. I also attempted to request Verizon to allow me to review their documentation leading up to the site selection. By my request for production of documents and things dated 5/9/14, but that too was denied. Exhibit 16 is the tax map for Plat 164, and it's also related to the very next Exhibit 17, which is a Google map. And I tried to give you the color one. You know, the blue rectangle is basically the blue rectangle on the Google map, and the green is basically the green on the Google map. And on page 4 of Exhibit 18, which is our hearing transcript of our March 6th meeting, on page 4, Ms. Martin testified that there were miles and miles of small lots. That's simply not true. On the Tiki Gardens side, there's huge open areas on both sides, the east and the west. The blue square is made up of 5 parcels. There are 4 100-acre parcels and 1 200-acre parcel there. The green side, I believe, is 12 parcels. There's 9 20-acre parcels, 2 5-acres, and a 10-acre, which was subsequently subdivided. It used to all be 20-acre parcels there. So to say that there were miles and miles of small lots is simply not true. Ms. Martin also testified she called all the large property owners in the area. I believe that was true. I personally called Osamu Kawabata, who's the owner of Kawabata Family Partners on 424, and Naoye Akagawa of Shellstone Realty and Ainaloa Development on 428, and both informed me that Verizon never contacted them. And these are the owners of the big blue rectangle. Second reason, Verizon, there is already coverage at Tiki Gardens and my property by both Verizon and AT&T. I used my phone there when I went to visit. I even borrowed one of my coworkers' phones just on Monday and made a call with Verizon, and it worked. So I have coverage in front of my property of AT&T and Verizon. I just want to put that on the record, and I have no doubt about that. Exhibit 19 is just another Google map that I prepared, and just to try and explain why I think I have coverage or why I know I have coverage, and they don't have coverage in Ainaloa. If you look at those white lines that kind of connect right below the Ainaloa word on the map, it's basically about equidistant from the Shure Foundation Tower to the middle of Ainaloa, as well as from the Pahoa Tower to the middle of Ainaloa. It was roughly about 2.7, 2.8 miles. And it's pretty easy to just use common sense to see that it's probably not reaching the side towers there. But to the middle of Tiki Gardens, which is above Ainaloa Boulevard, it's like 2.25 miles. And again, this is not very accurate. They just used the measurement tool on Google. But I'm pretty sure I have coverage from the Shure Foundation tower because I can use both a Verizon and an AT&T phone right in front of my property. Third reason, Verizon already has a viable site at the Ainaloa community. On Exhibit 18, page 4, Ms. Martin stated, hold on, I have to use my contact here, sir. Exhibit 18, page 4. Right in the middle of that big paragraph. Well, those are set aside by the homeowners association or the developer, the homeowners association for future parks. And so they thought, well, that would be perfect. Why don't you put it someplace there because we really, really need to set it. So we tried that and we actually got the go-ahead from Verizon to do that. I pulled the title report, I can see there's an obstruction on that parcel that they can't. That this company, the Ainaloa Community Association, has some of money to purchase the rights for telecommunication on that tower that's at their community center. But they didn't realize that they were signing away rights to all their other property. So when we went to them, they said, well, we're going to charge you, we'll let you do it, so we're going to charge you this huge amount of money. So she went back to Verizon and they said no. So the way I read that is they could put the tower there, they just don't want to pay it. And according to the use permit application, Verizon is the largest mobile network operator in the United States with 98.9 million retail connections. They were a joint venture of Verizon Communication and UK-based Vodafone. So Verizon purchased a 45% stake in Vodafone, or Vodafone's 45% stake for $130 billion in February of this year, 2014. And I'm pretty sure they could afford it. I would like to offer a comparison of the Tiki Gardens site to Verizon's 2006 denial of a similar tower at Orchidland, which was 104 feet high. The current tower is 105 feet. And that's the subject of the findings of fact, conclusions of law, and decision that order I have repeatedly referred to. Tiki Gardens, as I mentioned, is 105-foot tower. The Orchidland is 104 feet. The proposed site at Tiki Gardens is 8,100 square feet. And at Orchidland, they were all 2-acre lots. My estimate, if I were to build a house according to the existing setback, my house would be approximately 100 feet away, 150 feet away from the tower. And that's compared to 200 feet away for Mr. Pa and Mr. Hoskins at the Orchidland project site. Tax map, Exhibit 20 is a tax map for building 610. Again, the red was the proposed subject tower, and the two yellows was Mr. Hoskins and Mr. Pa, located directly across the street, just like we are now. Exhibit 21 is a letter from Mr. Pa to the previous planning director, Mr. Nguyen. Exhibit 22 is a letter from Mr. Hoskins. I'm sorry, I should address that. So again, that was the planning department. Mr. Pa was the owner of parcel 40, and Mr. Hoskins was the owner of parcel 42. Exhibit 23 is a position statement from the Orchidland Community Association, and the impacts that I'm trying to explain to you here today are almost identical to theirs. They mentioned adverse visual effect on properties, and in their letter, it's referred to as aesthetic impact. I feel like there's an adverse effect on my property values. In their letter, it's property value diminution. The tower fall zone affects multiple properties in the roadway, and they describe theirs as the proximity to adjoining homes and property lines. And I feel like Verizon does not have to locate the tower at the proposed site, and they tell the same thing that they explained under their alternative sites area. If any difference, my family's situation is worse. Our parcels are 1/10 the size of Orchidland 2-acre parcels. If we didn't happen to own all 4 lots right across the street, I think there would be other families here with me today opposing the tower, but my family owns all 4, that's why I'm here by myself. In actuality, it's hard to believe, but if you added the area of all 4 of my family's 4 parcels, the 4 parcels Verizon is purchasing, the proposed tower and buffer area, and the roadway, it wouldn't even add up to the area of the 2-acre lot. They were going to site the proposed tower. If I may, I just want to change direction a little bit and discuss discrepancies, specifically in Southwell Partnership's use permit application, which is Exhibit 24. I feel Verizon didn't show diligence in preparing this use permit application, and by that I mean legal carefulness. At the first meeting, I mentioned how there was contradicting information between the application itself and the historical properties assessment that was an exhibit in the back. I won't go over that in detail again because it's on the record. But this conflicting information prompted me to find out what this Bureau Veritas North America was all about. Exhibit 25 is a letter from Bureau Veritas to Mr. Puna, our planning director. They appear to be following protocol by investigating historic properties, religious, cultural resources. And it seemed like TS Dive, who did the historical assessment, was relying on Bureau Veritas. But on page 2, the third heading on the current land use, it says the subject parcel is vacant, undeveloped, and covered with heavy vegetation. And we all know that's not true because in the application, the realtor who was selling the property said the property was recently cropped. Of all the descriptions in the application which contradicted, Bureau Veritas, who apparently was the only one to inspect the property at that time, was the most inaccurate. Exhibit 26 is a planning department letter from Mr. Kanula sent to Bureau Veritas North America Inc. dated 9/26/13. On page 2 of that, Mr. Kanula is informing them about information on any native Hawaiian cultural, religious, or burial sites, historical places, artifacts, and other related concerns may be obtained through the State Historical Preservation Division of the State Department of Land and Natural Resources. They were suggested to contact State Historic Preservation. Next exhibit, 27. That is an actual confirmation from State Historic Preservation regarding the previous application in 2005. So Verizon used to do that in the past. It's normal practice. They did it in the past. But as far as their application they submitted on 12/11/13, I don't believe they did that. Exhibit 24, which was in their application on page 10. This is under the Exhibit C, which is the historical assessment. A review of the archaeological literature, historic maps, and information provided by Bureau Veritas North America show that the project site is unmodified and lava tube caves may be present. Caves may contain cultural resources. Based on this situation, it is recommended that an inspection by a qualified archaeologist be conducted for the entire parcel. TNKA B 1610256, the subject site. So they were basically informed by the planning director to contact State Historic Preservation. And they were informed by the archaeologist they hired that it's recommended that an inspection by a qualified archaeologist be conducted for the entire parcel. But based on the application submitted, neither was done. Based on review of the use permit planning, the first week of April and the end of May, still neither was done. Unfortunately, Verizon denied my request to review their file documents, but assumed still neither was done unless they want to introduce evidence at this time. On Exhibit 20, same Exhibit 24, on page 5 of the application itself, Again, it's an Ainaloa Community Association could not rent to Verizon because of the deed restriction. I feel like this is misleading. As I mentioned earlier, Ms. Martin testified on 3614. They could have located it at Ainaloa, but Verizon didn't want to pay. I feel like my family shouldn't have to suffer a loss because the Ainaloa board approved the telecommunications easement on their property, and now Verizon doesn't want to pay the requested rent. The homeowners in Ainaloa were most likely fairly compensated when they entered the agreement with the company. If Ainaloa homeowners really want the service and Verizon doesn't want to pay the requested rent, Ainaloa could assess the difference amongst all their homeowners equally. In actuality, there are 3,632 parcels in Ainaloa. They could assess each owner as little as $2 a month and have over $7,200 a month to pay without Verizon paying anything. The highest rents that I'm aware of on the island are probably at the Kaupulehu Tower, where AT&T pays around $8,000 a month for 4 spots. If they just simply didn't want to pay, a lot could be purchased in Ainaloa. There are currently lots available on the 4 closest streets in Ainaloa to the subjects. I really feel I shouldn't suffer a loss because I have service at my property, Verizon and AT&T. On page 5, it's number 10. It says, I attempted to meet the adjacent landowners without success. This is false. No one from Verizon ever tried to contact me before this application was submitted. And I mentioned earlier, on the second to the last page, also co-partnership use permit application has an overall site plan showing a 20-foot side yard setback. That's incorrect. Page 4, this application. The proposed freestanding tower complies with the minimum setback required of 20 feet or 1 foot for every 5 foot of tower. That's incorrect. Exhibit 18, which is the Planning Commission hearing transcript dated 3/6/14. Just on page 2, and I believe that's Jeff Carroll's testimony. It's quoted, this is the applicant's site plan. Just for reference, on your right side would be Silver Solar Court Road. So access would be from the right side of the map. The actual location of the tower with the facilities will be located near the rear portion of the lot. For this particular tower, being 105 feet in size, the setback ratio for a freestanding tower is 1 foot for every 5 foot. For a freestanding tower, so being 105 feet in size, the setback would be 21 feet from any boundary line. According to the site plan, it appears to meet those setbacks. Jeff states it appears to meet those setbacks because the overall site plan incorrectly shows the 20 feet. The plan should show the correct 21 feet. The tower height and setback is so critical. Mr. Kunua clearly stated the 2 types of height calculations in his letter dated 9/26/13 to Bureau Veritas North America. That was on the first page of Exhibit 26. He clarified that for them. Another peculiarity that I found is one plan on the last page, the last 2 pages of the application. One shows a monopole, which is just like I used in my Exhibit 6. And the next shows a fake pine tree. If you go to the last page, you will notice a big pine tree does not fit in the 20-foot setback either. It kind of encroaches outside of that. That's on the last page of the use permit application. You know, 1 foot discrepancy causes plans to get returned and prevents people from building simple structures like sheds and garages. A 1 foot discrepancy on a 105-foot tower can be patched up. Again, on Exhibit 24, page 9, granting of the proposed use will not be materially detrimental to public welfare nor cause substantial adverse impact to the community's character or to surrounding property. The application states the pole is designed to resemble a pine tree and be visible from Ainaloa Boulevard and a few residences. There are no pine trees on the lots Verizon is purchasing. In fact, it's been grubbed and is void of all trees. Many of the trees in the surrounding properties are smaller odia trees. The tower will turn service or court into an industrial-looking zone. A thick pine will stick out as bad as an undisguised tower. Exhibit D of Southwell Partnership's use permit application is misleading. That monopine looks like it's only about 40 or 50 feet. I'm sure Verizon has a picture of a 105-foot tower somewhere. I feel like it would be more like my exhibit 6. There's no facility removal plan in the application. For these properties, landowner is protected because lease agreement will describe when, how the tower will be removed. Incentive for Verizon to remove it is the fact that they would probably have to pay rent until it is removed. If they own the land, there's nothing motivating them to remove it. Although planning department recommendations include removal within 120 days, the actual facility removal plan needs to be articulated since Verizon will actually own the site. In Exhibit 29, this is a letter from the Land Use Commission when they were working on the previous site in Orchid Land. Item 2, we recommend that the applicant articulate a facility removal plan in the event that use of the facility is discontinued in the future. All of this is stuff that Verizon has been aware of on previous applications, yet they chose not to do that. 7, the use permit application process requires Verizon to post a sign at the property notifying the public of the nature of the application. Exhibit 30 is Hawaii County Code Section 25212P. The sign shall remain posted until the application has been granted, denied, or withdrawn. The applicant shall remove the sign promptly after such action. Exhibit 31 is General Dynamics letter or affidavit to the planning director dated 12/23/13. This looks correctly done, but when I went to the site the first week of March, April, May, and June, the sign was not there. Planning Commission Rule 7-4B also states the same regarding posting of signs for public notification for use permits. It reads exactly the same. The sign shall remain posted until the application has been granted, denied, or withdrawn. If the sign was there, maybe more people would be concerned, but we'll never know. Also, the sign appears to be on the wrong lot. If you look at the picture, you'll see that white fence in the background. If you see that white fence in the background, it's in front of parcel 54, not 56. They even posted in the wrong location when they did. 8, Planning Commission Rule 7, use permits, more specifically 7-2E. It states the certificate of clearance from the county finance or director of finance that the real property taxes and all other fees relating to the subject parcel have been paid and that there are no outstanding delinquencies. Parcel 56, along with parcel 54, 55, and 57 are all delinquent in the taxes as of today. If they failed to make their February, I think it's February 20th payment for all 4 parcels. I have batch of statement, if I can admit that here. 7.3, incomplete application states the director, on behalf of the commission, shall neither accept nor process an application which is incomplete as to form and content. They're currently delinquent on the taxes. 9, Rule 4, that's 5C. I believe the applicant was to serve notice on the same people about this contested case that they do for the first and second notice. I'm not sure if that was done. In summary, the discrepancies I noted in Southwell Partnership doing business as Verizon Wireless's use permit application submitted on 12/11/13 include the following. It was conflicting information regarding the condition of the site and lack of follow-through with the historical properties archaeological assessment. There was misleading statement that the Ainaloa Community Association site was not usable. False statement about attempting to meet with adjacent landowners. There's a definite discrepancy in the overall site plan setbacks. I thought they had a misleading modifying exhibit information. There's lack of a facility removal plan. It failed to adhere to Hawaii County Code Section 25212B and Planning Commission Rule 7-4B, rules for signposting. Property taxes are currently delinquent and should prevent Verizon from moving forward with the application. And Rule 4-5C, regarding survey notice, was not followed. For these reasons, Verizon did not exhibit diligence in the application, and again, defined as legal carefulness. There are also discrepancies on cell phone partnerships. Doing business as Verizon Wireless' statement of issues, Exhibit 32. Exhibit 32 is a statement of issues, dated May 8, 2014. Everything I looked at, the application, statement of issues, it only states to improve coverage in Ainaloa, where they state there's a large coverage hole. There's no mention of improving coverage in Tiki Gardens at all, anywhere. The reason is we have coverage both for Verizon and AT&T in our township, and I'm sure of that. On page 2, in the middle of the second paragraph, it states the land may not be suitable for a tower. Its location will not provide the required coverage. Topography renders it unbuildable, or the subsurface is insufficient for the tower's foundation.